Good afternoon, all. This application hearing is in the matter of CFI 069-2024 before His Excellency Justice Sir Jeremy Cooke, and is being held by way of video conference with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by KBH Limited. Lead counsel is Mr. Paul McGrath KC and Mr. Tom Stewart Coates. The defendant is represented by Hadaf & Partners and lead counsel is Mr. Nicholas Cherryman. Thank you, Honour.
Thank you very much. Mr. Chairman, it's your application.
Hello, Your Honour. Can you hear me clearly?
Yes, thank you.
There's a slight echo I'm hearing. Do you have that?
No. Is it your end or our end? It's probably your end.
Hi, can you hear me now?
Yes.
Someone's done something helpful to reduce the echo, remove the echo. So thank you, whoever that was. Your Honour, this is the defendant's application for summary or immediate judgment, alternatively a strikeout, and if we're not successful on that, for security for costs. And there's a further application for an extension of time, which is contingent upon the decisions on the first two applications. Your Honour, there's been a skeleton from both sides and there's a bundle that's been filed. Your Honour, to what extent have you had an opportunity to peruse materials, I might ask?
I'm pretty familiar. I've read the skeletons. I've read the application. I've read the witness statements. I've examined the particulars of claim.
I'm grateful for that. So I will jump right in, if I may.
Please.
This claim or this application arises in the context of a claim that's stated in the claim form to be for a sum of some $24 million. In actual fact, the claim is more substantial than that as a matter of quantum. If one does some maths looking at the particulars of claim, it's more like $35 million. Nothing matters for present purposes as to that. The claim is based upon a series of allegations relating to 5 particular commodities trades.
Yes.
And it's said that in some way that they are fraudulent, being based upon allegedly defective or sham bills of lading.
Yes.
The claim was commenced in September last year, and my clients promptly sought a further information by way of a request in the usual way. And there was a response to that, which my clients are unhappy with. We are unhappy with. We say it wasn't a proper response. And in parallel to that, there were various exchanges between the parties in the autumn of last year in relation to the question of the resources of the claimants. The first of whom is a UAE entity, and the second of which is an entity domiciled in Singapore. And we had concerns over their financial well-being in the context, obviously, of a security for cost application and their ability to meet any adverse costs order in due course. There were exchanges about that and exchanges of financial information from the lawyers for the claimants. That all gave rise to the application, which is presently before Your Honour. We do say that, as is evident from our skeleton and the evidence we filed, that the pleadings are inadequate in many respects. We have focused our application in relation to the poor pleading based upon the damages. We say it's insufficiently pleaded. We've given them an opportunity to do better through the request. for further information. Things didn't get any better. In response to the Part 24 strikeout application, there is no attempt to improve things at all. No evidence is advanced to support the claim for damages at all. So all of which will be matter for further submissions shortly. What we've done is focus the summary judgment application in a surgical way on the failure to put forward any proper case in relation to damages. And we do say that based upon the evidence and the circumstances of the case, the claim for damages certainly stands no realistic prospect of success. And in circumstances where, in particular, the claim for fraud is dependent upon the damages claim, this claim is hopeless and should be summarily dismissed, subject to immediate judgment, struck out, however one wants to put it, under the rules. It is relevant to note the way that this claim for damages arises as it has been pleaded. We do say that the entirety of the pleading is weak. So as I said, our application is specifically and more clinically focused upon the failure to make any proper case as to damages. It's, put it politely, an unusual claim in the way that it's been pleaded. And if one starts with the pleadings at pages 8 to 9 of the bundle,
Yeah.
What we see is that the claimants at all material times have been represented by, it appears, one individual, a Mr. Garg.
Yes. Well, I've read these particulars, Mr. Chairman.
Yep.
It's an odd claim. It's an odd claim in this sense that the immediate question one answers is what was the purpose of circular trades of this kind, and that raises all sorts of issues. But you haven't produced any evidence at all to challenge any of the basic factual material in relation to representations and reliance. So it's only damages that you say is inadequately pleaded. Is that right?
Your Honour, yes, that is right.
Yeah. Right.
It's
well,
also
let's go to why that makes all the difference for the purpose of your strikeout or summary judgment applications.
Yes. If we jump straight to that, if we jump to paragraph 38 of the particulars of claim, I've got page 22 of the bundle.
Yes, I've got it in hard copy, in fact, as well as on screen.
Yeah. The lead up to the claim for damages starts at really 38.
Yes.
As a consequence of the issues of veracity, those various things are said. And then it's said that para 40 that Keshav it has suffered considerable loss and damage, and it's explained in general terms said in general terms how that's arisen.
Yes.
And then the particulars appear at paragraph 43.
Yeah.
And Your Honour, if I may, I will take you through these and just hopefully demonstrate by way of comment how they are inadequate. Yes. The first, so there seem to be seven, or so I should say there are 7 limbs of damage under these subparagraphs. It's numbered through to 43.8, but it's actually 7 limbs of damage. The first one is a modest one and appears to be based upon a differential, or the delta between the purchase price and the sale price under the trades.
Yes, well, that's straightforward enough, isn't it? May not be very much. May not be very much, but it's straightforward enough. Yes.
I'll make a comment about it towards the end, if I may. 43.2 it said there's direct losses have been sustained because of the requirement to make early repayment of credit facilities, and specific amounts are mentioned.
Yes.
And as we've adverted to in our skeleton, there's no explanation what the requirements are or were to have made quote unquote early repayment of the credit facilities. We simply don't know what the terms were of those facilities, what the status was of those facilities at the time that repayments were made. And we're totally in the dark about that. Keshav is entitled, then it said that 43.3, as part of that second claim for damages, Keshav is entitled to and claims the cost of those early repayments, including but not limited to the loss of interest on the cash reserves, and to make those repayments, used to make those repayments, the same to be the subject of evidence. So it says the cost of those repayments, including but not limited to. Well, presumably Keshav must know what the costs were to make those repayments, and could and should have particularized what they are. The lost interest on the cash reserves, just pause there for a second. So it said that there were cash reserves, whatever that means. It isn't said what the terms were of those cash reserves, and that's relevant because the claimants are trying to claim the loss of interest on the cash reserves, which they said they had to have recourse to pay off those debts. But one comment there is, one would have thought, if anything, the interest that was accruing on the credit facilities would presumably be more than the interest that was accruing on any alleged cash reserves. So in fact, there wouldn't be any loss occasioned by having to pay those off. But anyway, none of it is explained as to how these things arose. 43.4, as a result of the repayment of their respective credit facilities, as aforesaid, and their inability to obtain alternative credit financing, it's not said there or particularized which credit facilities have led to which problems, what the inability, how the inability manifested itself to obtain alternative credit financing. Again, not explain what that means, what attempts were made. KJ UAE and KJ Singapore were unable to pay the balance of contracts. What contracts? What balance? Into which they had entered in advance of the said closure. Well, the said closure, I mean, there seem to be several different closures relied upon. This is now all finding voice in one said closure, with the result that they, no distinction between the two companies, they forfeited, whatever that means, the advance payments. What advance payments, and in what circumstances, that they had already made to suppliers. What suppliers? And or we don't know which, incurred penalty payments under those contracts. And then it's right to say, and this is a common feature, and the other side obviously are keen on this, they do give specific numbers, but it really begs the question, if you can give specific numbers as to what you say you've lost, it must mean that you've been able to identify the material to say how this all arose, and to compute how these numbers came about. 43.5, another head of loss, or limb of loss, I should say, further and separately, as a result of the closure of their credit facilities, again lumped together, and their inability to obtain alternative credit financing, KG UAE lost profits of $3 million. In KG Singapore lost profits of $465,000 from their resultant inability to fulfill their obligations under contracts entered into prior to the said closure. We don't know what contracts are being referred to here, which contracts pertain to which particular claimant company, when they were entered into, and again we got the said closure. Which closure of what accounts? We just don't know. Alternative credit financing is referred to. We don't know what that means and how they went about trying to find quote unquote alternative credit financing, and how that alternative credit financing might have related or been relevant to their inability to fulfill obligations under unspecified contracts. Another head of limb of loss is 43.6. as a result of the closure of their credit facilities and or KG UAE's repayment of its loan to Mashreq, their inability to obtain alternative credit financing, KG UAE and Singapore lost the opportunity to generate profits under anticipated contracts in respect of which it had entered into memoranda, plural, of understanding with third parties prior to the said closure, and then amounts are mentioned. Same comments again, but the claim is getting, or the claim for damages are now getting vaguer. What lost opportunity to generate what profits under anticipated contracts? What contracts in respect of which it had entered into memoranda of understanding? What memoranda? With third parties. What third parties? Prior to the said closure, again, put in the singular. Just pausing there, as you'll see in the RFI in a moment, we've asked for copies of those memoranda and they haven't been forthcoming. And if you remember that the Mashreq facility is a facility that the claimant voluntarily paid off. It isn't one they say that they were required to pay off. At 43.7, another limb of damage, yet further and separately as a result of the closure of its facilities with Bank of Baroda and Bank of India, and or the early repayment of its loan from Mashreq Bank, and or its inability to put in place alternative credit facilities, and its resultant inability to engage in ordinary commodities trading. So a series of clauses there, which are all just, again, put at a high level of assertion. But the sentence continues, KG UAE lost the benefit of sums that it had invested in anticipation of being able to trade raw cashew nuts from Ghana, Nigeria, and the Ivory Coast, including but not limited to its cost of obtaining registration in those territories, operational costs, and the renting of warehouses. All sorts of questions, of course, immediately come to mind. Most obviously, what are the ordinary commodities trading? And then KG UAE lost the benefit of sums it had invested. What sums? It had invested in anticipation of being able to trade raw cashew nuts from then, let's say, 3 separate countries. To the benefit of sums, we don't know what sums they were, which includes but isn't limited to its cost of obtaining registration in those territories. No particulars about that. Operational cost, don't know what that means. And the renting of warehouses, no specificity. The full amount of the UAE's losses will be the subject of evidence, including expert evidence at trial. Doesn't say why expert evidence is needed, it's just a sweeping assertion. But KG UAE's present position is, and then it gives quantum, quite a precise number, $1.04 million. The final limit loss.
Not less than,
sorry.
Actually. Not less.
I'm so sorry.
So it's setting a minimum figure without a max.
Yeah. But they've been able to compute that, but we don't know quite how, what basis, and how any of that arose. 43.8, the final limb, yet further and separately as a result of the closure of its credit facilities with Bank of Baroda and or the early repayment of its loan from Mashreq Bank, and that's the one that was paid off voluntarily, and or its inability to put in place alternative credit facilities, KG UAE has lost the opportunity to invest in alternative suitable investments, including but not limited to potential investments in sugar refining joint venture, in a sugar refining joint venture in Liberia, and a multi-territory biostimulants manufacturing business. Again, lost the opportunity. Well, what do you mean by that? What opportunity? How has that arisen? How was it finding voice? How real was it to invest in alternative suitable investments, including but not limited to? No particulars about what these are, other than just sweeping references to a sugar refining joint venture in Liberia. Well, what joint venture in Liberia? Multi-territory biostimulants manufacturing business. What business? The full amount of KG's losses will be the subject of evidence, including expert evidence, in due course. Not less than, and the damages are put up, not less than 5.04 million. Again, somebody has presumably had the material before in front of them, documentary material, to be able to put that number forward. The vagaries of the pleading were the subject of an RFI.
Yes, where's that?
So if I was going to take you to, actually, for convenience, the
answers.
The answers.
Thank you.
Which begin page 156 of the bundle.
Yeah.
It is right that it is on one view a long document, but it is a question of do feel the quality, don't mind the width. They are perfectly proper requests for particularization, as even a cursory read of them will reveal. And I won't take you through the anterior request or the request leading up to the claim for damages, but Your Honour will recall that the claim is pleaded on the series of oral conversations based upon a series of in persona meetings with allegedly with a handful of people who allegedly were agents at the time of the defendant, and all of those matters were the subject of quite proper requests for further information. In particular, how it is said that the individuals who were said to be agents of the defendant were in fact held out as or are said to be agents of the defendant. All of that perfectly
well, I understand all of that, and the whole thing cries out for explanation. But what's your case about whether these people were authorized or whether they were making money on the side for themselves or what?
Yeah, well, that's a matter for any defense.
Well, I'd like to know, Mr. Cherryman.
Yes.
What's your case?
Yeah, well, our case is that the claims are denied, and these people, if any wrongdoing was occurred, they certainly weren't agents of the defendant. Beyond that, it's all a question of investigation and particular instruction. It's potentially that whole area.
You say they were off on a frolic of their own, making money on the side by setting up sham deals.
If it is right that there's been wrongdoing, again, it's something we deny, and it's something we haven't looked into in any depth. It's fair to say there's a number of well, you say that, but Your Honour, but these individuals aren't any longer.
I would have expected you to.
Yeah, we have looked into it to a degree, but the individuals involved are no longer with the company. They aren't at our beck and call. And I think there are five.
None of the five. None of the 5 or 6.
I'd be corrected if I'm mistaken,
yes,
but I believe none of the five are any longer with the defendant company. So they're not at their beck and call, sitting in an office where we can go and interrogate them.
Yes.
The claim for
there we are.
Well, it also arises in a situation where there's actually putting aside what the claimant says and putting aside its own allegations of loss. There's no third party that said that it was being defrauded by anything, which is an unusual feature. You would have thought if there is some dishonesty here, that somebody's been defrauded, somebody's lost money, and again, put aside what the claimant says about it alleges about its own loss. There's no third party that suffered any loss.
Well, on the face of it. The claimant may have done, and the defendant may have done. If, as you say, these people are involved in making money for themselves by taking a cut out of supposed deals, or doing circular transactions, all of that's speculation, so far as I'm concerned. But on the face of it, we've got a pleading with a statement of truth about representations and so on, and we've got a statement of truth in relation to agency, and you haven't denied any of it. So I have to work on the assumption that the facts pleaded are true for the purpose of your strikeout or summary judgment application. And the whole thing is simply focused, as I see it, on the question of unparticularized loss and damage. Have I missed something?
One important point is that it is said in our evidence that the claim is denied. To be clear.
Yes, of course.
Paragraph 7.
I'm clear about that, but not with any detail. So that if you were simply to plead to this and say denied, there'd be the usual problem of a party who simply makes bare denials but asserts no case of any other kind. And that
Yes.
might give rise to a request for particulars against you, should we get that far.
Should we get that far? But
Yes.
what, not, but
Let me
nonetheless,
tell you, let
Yeah.
me put my cards on the table, Mr. Chairman, so you know
Yes.
exactly where I'm coming from. Yes, there's a fair point that you make about absence of proper particulars in relation to various heads of loss. But why is this a strikeout or a summary judgment? Isn't the simple answer that you should be applying to me for further and better particulars, and I should be making orders that there should be such particulars?
Well,
and if there was then a recalcitrant refusal to give them, then we'd be in a different ballpark, wouldn't we?
yes. Well, I think procedurally, we made the request for further information. We've seen the
Yes.
responses they've given. And let's just focus for the moment on the damages ones. Your
Yes.
Honour will recall that most of the responses are littered with a refrain that they're disproportionate, inappropriate,
Yes.
and they're not going to answer them, already been sufficiently pleaded.
Yeah.
It is right that as a matter of procedure, one could apply for a specific order that they be answered, but it's equally right that as a matter of procedure, my client was entitled to make an application for Part 24 as a matter of procedure. I appreciate the other side.
Entitled to, except that that's always a last resort, isn't it?
Well,
the ordinary position would be that you would apply to the court and say, look, these particulars are hopelessly, pathetically inadequate, and therefore I have a court order that you produce them. And then
Yes.
if they fail to produce them, other options are open with unless orders, and then finally strike out for failure to observe a court order. But I mean, that would be the ordinary position, Mr.
Yes.
Chairman, wouldn't it?
I agree, but we're not in the ordinary position. And actually, events as they've unfolded have actually confirmed that the approach my client has taken was appropriate and proportionate. We'll look at the authorities in a minute, but it behoved the claimants in response to the immediate judgment application to put in evidence explaining how the damages arose. They had that opportunity and they didn't do it. So we're left with a situation where, in a sense, the greater includes the lesser. The immediate judgment application was an opportunity, that the response to that was an opportunity for the other side to attempt to make good the deficiencies in their pleading in relation to damages. They singularly chose not to do so. And the authorities are very clear about this, that they should have done, if there was something they wanted to say, the obvious, well, first is a matter of common sense, say it, let alone you're obliged to say it. And the authorities go on to say, look, and if you don't, the court shouldn't give you yet another opportunity, unless there are, shouldn't give you yet another opportunity to try to fix the holes in your case. That's where we get to. Because the approach of the side really begs the question, because our requests are pretty simple. It's like, look, please do a better job in relation to your particulars on damages. And they say, no, we're not going to. But if it's right that we've asked that and they've refused to answer, and they've refused to put in evidence in response to try to substantiate their claim of damages and try to demonstrate why they do have realistic prospects of success, and they've elected not to do so, well, I'm afraid that they've made their own bed and they have to lie in it. That's why we're in an unusual position. We might be in a different position if they had, in fact, put in evidence and said, look, we think you should have got an order against us to make us answer these things. And without prejudice to that, by the way, here's the stuff that we would have said. And here are the exhibits we're relying upon, including, for example, the alleged memoranda. Here are the terms of the contracts. We think you shouldn't have done this. We're going to have a crack at you for costs and so on and so forth. Didn't do any of that. Mr. Singh singularly fails to address the merits. That's where we get to on the that's why we're here today. And there are not even any voluntary particulars provided without prejudice to the fact, look, we think you should have done a part 19. Here it is. We're going to put this in front of the judge, and we're going to and we're going to sort it out that way. This is what you should have done, and proof of the pudding's in the eating. Here it is. Nothing. So on the face of it, any order along the lines that they say that we should be seeking would have gone absolutely nowhere, because they've had their opportunity to answer the failures in relation to the pleading on damages, and they have not taken advantage of the opportunity that they had. In that connection, sorry, I just lost the picture. In that connection, that there are various additional points that we rely upon. We do say that this is it is obviously a case based upon fraud. And the damages are a necessary element of that story, putting it simply. But I think more technically, the damages are, of course, a constituent part of at least a tortious claim or a deceit claim. So the pleading in relation to fraud and the claim in relation to fraud should be approached, we respectfully submit, with the same rigor, or with the rigor that is required and was adverted to in the Three Rivers case, where very strict rules govern the pleading.
Yeah, well, I'm very familiar with all of that, Mr. Chairman.
Indeed. So again, it really underscores our point that the requests that we made were perfectly proportionate. They were not overreaching. They were not improper. And it further underscores the wholesale inadequacy of the response to the Part 24 on the part of the claimants. These requests cannot be dismissed simply as requests for evidence and let's just see what comes out. That is not the approach that should be taken. The material that we're after is entirely within the possession of the claimants. We have no visibility at all on any of the things that are asserted to make out this very large claim for damages. And it cannot be onerous for the claimants to have pleaded this stuff properly. It cannot be onerous for them to produce the information in response to the request for information, and it cannot be onerous for them to put evidence in it in response to this application. And indeed, it isn't said that it's onerous. It's just said that we shouldn't be asking for it. That's what it said. Begs the question why they haven't put forward the material that we're after. The inference we say that arises is that the material doesn't exist, or insofar as there's any material, it doesn't support the pleading for damages. As I mentioned already, the evidence of Mr. Singh doesn't seek to support the claim for damages at all. It's a series of comments that he makes that this application is inappropriate for all the sort of rhetorical reasons that also find voice in my learned friend Skeleton. The failure to put in any evidence in response to this really underscores the fact that there is no substance to the pleaded case. Mr. Singh does make a reference at paragraph 60. Maybe we should look at that on page 76 of the bundle. So paragraph 60, that Mr. Singh, in the last sentence of that paragraph, he says something to the effect that details of losses are typically the subject of later particularization, often via expert evidence. Just pausing there, with respect to Mr. Singh, it is the function of pleadings to properly particularize your claims, in particular in a case of fraud, where very strict rules apply. And if and insofar as is appropriate in the light of the issues which emerge from the pleadings, it may be appropriate for expert evidence on particular issues to be directed by the court, subject to the usual strictures. And then there's a comment made, but it's not required in order for a defendant to answer the allegations which give rise to liability. Well, in a case, the defendant's entitled to know the way that the case for damages arises, so that it can either apply to so we can respond to it appropriately or criticize it appropriately, or if in due course strike up those parts if the pleadings were properly made in the first place. He also says, again, to echo what I just said earlier, he asserts in paragraph 62(1) that the pleadings are sufficient. So that's the position of the claimants. We said they're wholly wrong about that. And they said it's a matter of evidence of 62.3, which will be disclosed to ETG as part of the standard and or specific production phase in these proceedings. Further investigation of the evidence as provided by all parties is likely that Keshav and indeed ETG will amend their statements of case to reflect that evidence. So he's playing the long game here. But again, it also missed the point that the material in relation to the alleged damages is entirely within the bailiwick of the claimants. And it's not said that there's a problem producing that. There would be a problem producing that information. The principles on part 24, I'm not going to trouble your honour with those. That's very well known, and they're repeated in a number of the judgments of the court, including, of course, your own. From time to time, both parties, I think, have referred to the case of GH Capital and Hague. Nest Investments is another one, but they're very well known. There have been some other relevant comments which are useful in this case. There's a case that we recently added to the bundle today, the Bank of Singapore against Marge Holding. I believe that's at the very back of the authorities bundle. The decision of René Lemaire. And I believe that is page 1339. Your Honor, I don't know if it may be that it's only, sorry, Your Honor, it may be that you only have it in electronic form. For which our apologies. I should say my apologies.
You think it's in the bundle? Let's just
I'm told it's in the bundle.
It's there. Yeah, it's there, yes.
I'm grateful. So it's a judgment from November 23 of Justice Lemieux.
Yep.
And if we
what are we looking at?
So there's a recitation.
Speaking across one another. It's the usual problem of speaking across one another. But tell me the relevant pages or paragraphs you want me to look at.
Of course. If we para 81.
Yeah. Yeah.
There's a reference to the principles. A couple of points just to draw out. Para 85.
Yeah.
There's a comment that the learned judge makes, which is actually a comment that also was articulated in the Emirates NBD case, which is referenced to 83, which Your Honour may recall, as you were the first instance judge who was successfully upheld on appeal. But anyway, 85. In opposition to the application for immediate judgment, the defendant submitted that the court should further examine questions or issues and submitted that these queries cannot be decided at the immediate judgment application hearing. For example, in arguing that the bank arbitrarily and unilaterally re-evaluated the loan-to-value ratio of the Lansdowne bonds, the defendant submitted that the parties should be allowed to appoint a banking quantum expert to file an expert report. As such technical queries related to banking should not properly be decided by the court as part of an immediate judgment application hearing. The defendant submitted that the court should permit them to provide evidence after further investigations into the claim and counterclaims. I am not persuaded by those submissions. It is not necessary for a party responding to an application for immediate judgment. It is necessary for a party responding to an application for immediate judgment to put forward sufficient evidence to satisfy the court that it has a real prospect of succeeding at trial. If it wishes to rely on the likelihood that further evidence will be available at trial, it must substantiate that assertion by describing, at least in general terms, the nature of the evidence, its source, and its relevance to the issues before the court. The court may then be able to see that there is substance in the point and that the defendants are not simply playing for time in the hope that something will turn up. It is not sufficient for a defendant simply to say that further evidence will or may be available. The defendants are entitled to confine their evidence to selected documents and general allegations, but having done so and having failed to show by evidence what other evidence can be expected to be available at trial, the court will not speculate about whether there might be any such evidence, and if so, what its nature might be. And as I say, that echoes a similar articulation of that approach by the Court of Appeal in Emirates and NDB Bank, referred to at 83.
But what we have here, Mr. Chairman, is no evidence of any kind other than a statement of truth. And there's no evidence from your side. There's no evidence from the claimant side. How does this really help? In the ordinary summary judgment case, along comes the claimant. He's made his claim and he supports it with an affidavit or witness statement saying there's no defence to this action. And it's no good the defendant turning up and then saying, well, I think I might have a defence somewhere down the line without putting it forward. But in this particular case, we've got a defendant coming along who doesn't give any evidence at all and says the claim is hopeless without any realistic prospects of success because no evidence has been produced in support of the losses. It doesn't seem to me this helps me very much.
Well, we do say that in that circumstance, I mean, what this is an application by us criticising the other side's case. There's no application that we have to meet. That's the first point. There's no criticism. There's no application against us. There's no criticism made about the underlying merits of the case, other than they say that this is a case of fraud and they're entitled to plead it the way they pleaded. We made an application. We say they're wrong in the way they've gone about their case, and we're invoking the jurisdiction of the court in that context. The authorities are very clear. The Singapore Bank makes very clear, and it's just a matter of common sense. They're responding to our application. They needed to say, if they wanted, they had the opportunity, if they wanted to say why their damages part is good. Yep. And they decided not to go down that path. Well, so be it. That's on their head. That's where we get to with this. Yep. It may be, we say it should be a summary judgment application, and that for those reasons, the entire case should be dismissed. It's clearly, we say, in the circumstances, a classic try-in or a shakedown of a large commodities company where somebody's bringing a very optimistic claim, shall we say, to try and get a settlement. That's what we think this is really about. And if there was something in this, certainly the damages part, why isn't the evidence before the court in response to the application? Cries out for an answer, and there isn't one. I say nobody's made any application against us. We're entitled to make the application we did procedurally in the way that we've done, and that's what the rules allow us. And there we go. It is the sort of converse or the mirror image of the claimant making an application for summary judgment when the defendant has filed an acknowledgement of service but not put a defence in. Well, we're equally entitled as a defendant to make an application when we did after acknowledgement of service and prior to any defence having gone in. There's no requirement for us to have pleaded a defence or to say what our case is in response to the rest of the case. We've been focused on one aspect of it, which is unique, or I should say peculiar to the claimants, which is the damages that they say they've suffered. So we say it should be struck out. Well, it should be struck out whether it's pursuant to the Part 24 mechanism or whether it's through 4.16. As to the principles on 4.16, again, I don't know if Your Honour requires any help in relation to that. I think there's probably no real debate between the parties in relation to the principles there, and there's a number of times the court has said that there's a similarity in the approach. I'm sure both sides acknowledge. I think both sides would accept that there's the Part 24 is more focused on the evidence before the court, whereas the 4.16 is more focused on the way the case is pleaded. But whichever route one went down in this case, once we submit that you get to the same answer, that this case should be struck out, or indeed, even if the entire case is not struck out, certainly, you know, the damages are struck out. And we are left what we've got. It may be said, and it's not said in the skeleton, it may be said, oh, well, we should still be entitled to have a claim for nominal damages. Whether there have been, you know, there is authority about that, certainly in the English courts, where, you know, cases for nominal damages shouldn't be allowed to proceed, but they haven't said that that's what that would be their fallback position. So that wouldn't help them anyway.
As a matter of interest, has there ever been a case for nominal damages in the DIFC?
Not that I'm aware of, but
no.
So
well,
you would probably, so Your Honour, you would probably know better than me.
No, I wouldn't know at all. But I somehow doubt it in the limited history of the DIFC that anybody has ever brought a case where that's been the result. But you never know. You
never know. Well, certainly, anyway, in the commercial court in London, that there certainly have been authorities which strongly deprecate the bringing of claims or the continued pursuit of claims where it's purely nominal damages. It's just in
waste of time. Yeah.
It's a waste of time.
Is there anything more you want to say on that aspect?
I don't think so. I'll wait for a reply. I mean, I've understood your Honour's comments.
Yes. Well, let me tell you what I'm inclined to do, Mr. Chairman, in order to cut things short. I'm against you simply on the basis that, however inadequate these particulars are, this is not appropriate case for striking out or for summary judgment. And what I was proposing to do was ask Mr. McGrath to deal with the inadequacy of the particulars, and if he really is maintaining a case that he doesn't have to give them. My inclination is to grapple with all the issues now and to make an order for particulars, further information to be given, and production of such documents as are referred to in the particulars of claim within a certain time limit, which we can discuss. And you can then have the opportunity to reply in relation to any particulars that Mr. McGrath suggests are sufficient as they currently stand. So that's my approach. I'll cover this in a judgment in due course. But the simplest thing is to try and grapple with things now in order to move this case forward and deal with all outstanding points. It's probably better that Mr. McGrath deal with the particulars and I can go through them with him first, and then you get the opportunity to reply should there be areas where Mr. McGrath contends that he's done all that he ever has to do. Does that make a certain degree of sense, Mr. Chairman, accepting on the chin that your major applications are not succeeding?
Your Honour, it does, and I've got a tough chin, so
very good. All right. Now, Mr. McGrath, let's just have a look at these particulars. First of all, do you seriously maintain that you don't have to give any more?
My Lord, in light of your indications during your exchanges with Mr. Cherryman, no, but then as we indicated and Mr. Singh indicated in the evidence, that the correct procedure would have been to...
Yeah, well, I'm with you on that, Mr. Goff.
Yeah, and my Lord, can I just...
The reason I'm going to deal with this is because although the correct procedure would have been for Mr. Cherryman to come and apply for further particulars and me to make the orders and set a time limit, the idea of going through that hoop further down the line is just ludicrous. We're here. I should deal with everything I can deal with as a matter of efficient case management, and that's what I propose to do. And I will say, Mr. McGrath, and I don't know if you want to deal with this. I mean, the whole arrangement is bizarre, isn't it?
It is unusual. The
that's one way of
putting it up to the claim, but the actual pleading of the claim, putting aside its subject matter, we say is vanilla in terms of the representation.
Well, I'm with you. I'm with you up until we get to the loss and damage. And the first head of loss and damage is perfectly straightforward, and I don't have any real problems with that. So you have, on the face of the pleading, a perfectly constituted pleading of a tort with damage. But when you come to the other heads, we do run into issues as to whether they are documents which ought to be produced because they're referred to in the pleading, and whether particulars of certain elements of the pleas should be given. In relation to actual quantification of some heads of damage, it's perfectly right, no doubt, to say that expert evidence will in due course from forensic accountants support the way in which it's done. But there are other elements which appear to me plainly to cry out for further information. Shall we go through those, and you can make your submissions on each particular head?
My Lord, I was just wondering actually if there was an even shorter route, if I can put it this way, right. If I can float it with your lordship. I appreciate that what you don't want is to send me off today, and then I come back and my answers to the questions are no, 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 and no. You're not having them, and then we have this debate in 4 months' time.
Exactly.
But my Lord, you've seen my client's attitude in terms of, if the court thinks that the answers were inadequate or could be better particularized and documents could be provided, then there was a route available for that. Now, recognition of the existence of that route obviously implies a recognition that one ought to then respond to that route appropriately if it had been invoked. And so working backwards for the purposes of today, plainly insofar as the losses claimed relate to particular contracts or memoranda of understanding as documents, my Lord, I've seen your Lordship's reaction to those requests, and it would seem to me entirely reasonable that insofar as such documents exist and are the basis of the claim for losses, then they ought to be pleaded out and or the documents themselves provided so that one can see the basis for the claims. And where I get into a little bit of difficulty, my Lord, dealing with it on my feet is not so much as those sort of requests, but the level of detail that one would need to go through in terms of sort of lost opportunities, etc. Now, you have seen that there was a reference to lost opportunities in a sugar issue and other matters.
Well, can I cut you short, Mr. McGrath, because those are the very points that I want to discuss and iron out with you now.
Yes,
I mean, I think we can go through this pleading and determine what is appropriate to be given now and what simply has to come up later by way of evidence and discovery. There's obviously a difference between pleading and evidence. That's a fundamental point. But it does seem to me that we ought to be able to go through this now, and I ought to be able to make orders about what you definitely should give.
My Lord, that's great. I mean, the difficulty I have is only knowing the specifics of some of the answers. But I'm willing to go along with your lordship and do my very best.
Well, I think you'll have to. I think you'll have to, Mr. McGrath.
I'm happy to do so. So
right. Well, let's start. Let's start by looking at 43.1. Let's take it one paragraph at a time.
Well, will we say that one is vanilla? That the figures are derived from what's actually pleaded, and in fact, the request should never be asked.
Yes, so the short answer is both sides have got the figures on that. They've got the contracts for the sales and purchase, and they can see the difference. And Mr. Cherryman accepted as much. So on the face of it, that's okay. And that's why I said you do have a completely constituted claim in deceit and tort, because we've got damages that are on the face of it clearly identified. So that's okay. Now, as soon as we get to 43.2,
Yes.
Again, it's probably easiest if I give you my initial view, and then you can argue against it, and
Lord,
Mr.
yes.
Mr. Chairman can do likewise when it comes to his turn. So, if we're looking at credit facilities that have been extended by the Bank of Baroda and the Bank of India, although of course you don't specifically refer to a document as such, it seems to me self-evident that in order to make this point good, you are going to have to produce copies of the documents that set out the terms of the credit facilities, and you're also going to have to produce the document that made demand under them. Now, the way the wording is put, it may not be absolutely straightforward to tie that in, but those are matters that are well within your control and which you could give. So if I were to order that you give further information as to, one, the terms of the credit facilities with the Bank of Baroda and the terms of any requirement for early repayment, the effect of it would be doubtless that you'd be able to produce all the documents which show that. Do you have any difficulty with that?
In terms of principle, no, my lord.
Right.
I can see the sense with respect to your lordship on both of those aspects.
Right. Now, when it comes to Mashreq Bank, where there was no demand for repayment, no doubt, I assume the basis of your case is that given the fact that the other banks had required it, it was blindingly obvious what would happen when you coughed up and said you'd been involved in sham transactions. And so therefore you took the step. And that appears to be to me a matter of evidence rather than anything else. But again, if there are documents which go to the early repayment of the loan from Mashreq Bank, it would make sense for those to be produced at this stage as well. You'll be aware that the provision for further information is quite unlimited. I can order you to provide such further information as I like. It's not really tied to the old-fashioned way of only producing documents that are specifically referred to and so on.
I accept that, my lord. There's no issue on that. I agree.
Okay, so whilst I think there's a bit more of a problem about the early repayment point, and I'm not requiring you to produce evidence from a witness who says, I thought about this long and hard and I decided this was the right thing to do in circumstances where the other banks had required it. Yeah. And if we talked to Mashreq Bank and told them what had been going on, they'd require the same. There ought to be some basis for the plea of making early repayment, including the documents that show that it was done.
Yes. And
in due course, Mr. Cherryman will no doubt want to cross-examine people about it, and there'll be issues of causation and I don't know what else as well. So that's 43.2.
Your Honour,
yep, go on.
If I might make one comment there, I think it would be more than useful if the claimants could tell us what the balance was under the different facilities as at the date of the repayment.
Wow.
Doesn't it speak for itself?
Well, I think in one sense, yes. It may be. What I would really like to see, of course, is this will come out in disclosure. This really goes to the point of, were these facilities in default already? Had there already been pre-existing demands to repay? What was the level of the credit facility at material times? Because there is a point that we have, which is behind some of our questions, which I think we put in our skeleton, is that these were going to have to be repaid anyway, and they were probably all in default. But that's a comment by me. So we wanted questions that go.
But let's not examine cases that haven't been pleaded.
I'm sorry.
I was just saying, my lord. I mean, if my friend wants to make out this case and seek appropriate documentation and information about it, he can make his case, and then we'll respond to it appropriately. But at the moment, we're saying and seeking to support a claim for loss of damages that we're claiming, and we say it as a result of these demands, and we shouldn't really then be required to explore in it possible lines of inquiry that my friend might like to explore at some point in the future. So we say what your lordship has suggested on the 43.2 is entirely sensible, and we wouldn't challenge that.
No, well, I'm with you on that, Mr. McGrath. What we're dealing with at present is your pleading.
Yes.
Further down the line, there will be disclosure following the defence, and if there is a plea in the defence, not only that there's a non-admission of any of this, but a plea that you would have had to repay in other circumstances or whatever. And in due course, all these bank statements will have to be disclosed, no question about that, to show what's going on. But at this stage, what I'm concerned with is this pleading.
Yes.
And issue hasn't been joined yet on the defence, though no doubt it will be. So I'm clear about that. Let's go on to 43.3. Now, lost interest on the cash reserves. Now, I can see that there's a question there as to, one, what the cash reserves are and what the lost interest is. But I need a little bit of help from you here. Obviously, there would have to be expert evidence to the extent that what was payable under the credit facilities in terms of interest and what you had by way of deposit and how the two interrelated and what the losses might be. But I do think it's necessary for you to specify what cash reserves you're referring to. In other words, are you referring to deposit accounts? Are you referring to some other forms of investment? What is it that's being talked about here?
Particularise the cash reserves that form the basis of the allegation.
Exactly so. Exactly so. Now, how you calculate the loss, of course, at the end of the day, but in terms of having a credit facilities, if we could get to disclose the terms of those, as we've already said, and now you have the cash reserves and you disclose the terms of those cash reserves, what are they? Then in due course, experts will have to comment on how the two interrelate and whether there's a real loss there or not.
Yes.
Then 43 point.
Your Honour, if I may, one observation.
Yeah, go on.
It's merely an observation.
It's probably easiest if you do interrupt, actually, and we'll deal with them one by one rather than wait for you to come back right at the end. So have your say now.
I'm grateful. Just one observation. It may well be that there is no need for expert evidence. Anyway, it's quite a sort of visceral reaction of a lot of lawyers, not the bench, to say, oh, we need experts. This may just be a matter of arithmetic.
It may indeed. It may be a matter of factual evidence as well. You know, what bits did we set aside? Because after all, if this was an ongoing business of some kind, there may be stuff that are quote reserves. There may be stuff that is being used in trading. And as we'll see from the later information that is given, there's questions of investments in West Africa and so on and so forth. I don't know anything about the business of these people, but simply what appears here. But we'll come to those in due course. So 43.4. Balance of contracts and advance payments and penalties. Now, you've managed to plead some figures here. So it's plain that there are specific contracts that are being referred to, and the information should be given about those contracts and the contracts disclosed. I can't see any issue about that. Do you take issue there, Mr. McGrath?
No, I don't push back on that, my lord.
Very good. All right.
Give me two aspects of it. One is advance payments that were forfeited,
Yes.
and the other one are penalty payments that may have been incurred. So we identify the contracts, which will identify the terms, and then we identify the forfeited advance payments under the particular contract or the penalties on both.
Exactly so. Exactly so. Good. 43.5. Now, lost profits. Again, you should be able to identify the contracts. You've been able to identify the lost profits. So that must mean you've got contracts of sale and purchase of some kind that give rise to the differential. So you should be able to disclose both the contracts and the basis of the figures claimed.
Yes. No pushback there, my lord.
Very good. 43.6. Lost opportunity to generate profits under anticipated contracts in respect of which their memoranda of understanding. Memoranda of understanding ought to be disclosed. And again, you've got figures set out. So you should be able to give, by way of further information, the basis upon which those figures have been calculated by reference to the memorandum of understanding. I take it that, again, we're talking about memorandum of understanding that are not in themselves enforceable legal contracts, but are effectively term sheets or something of that kind of sale and purchase, which give rise to the specific figures that are calculated. So you should be able to produce those and set out the basis upon which the figures have been assessed. Any issue there?
No, my lord, no.
Good. 43.7. Now, this is a bit more difficult, isn't it? Lost benefit of sums invested in anticipation of being able to trade raw cashew nuts from Ghana, Nigeria, and the Ivory Coast, including costs of obtaining registration, operational costs, and renting of warehouses. Now, do you have anything you can tell me about what this really means? It looks like simply a lost opportunities case.
My lord, from what's said there, and there was, if one turns to the answer that's given, I'm not sure how much further it takes it, but it says the claimant's position that they'd intended to trade raw cashew nuts in the states listed and had incurred.
Can you give me the page number?
Oh, sorry, it's the page 203, my lord, answer 62 to the requests.
Sorry, page again?
It's 203.
203, okay.
Answer 62, and halfway down that paragraph, your lordship will see the claimant's position is that they had intended to trade raw cashew nuts and had incurred costs in connection with preparing for those intended trades, including but not limited to the cost of obtaining registration, operational costs, and the renting of warehouses. And then because of the credit facilities, they were unable to effect the trades they intended to carry out. So it's a claim for wasted costs for work done. So I anticipate your lordship will say you can identify the costs that you say were incurred that you no longer were able, that were wasted.
Yeah, well, I think you should do that. Produce a list of those in question. I'm not, obviously, there are going to be questions of causation and goodness knows what that arise here, but that's all for the future.
Yes.
Mr. Chairman, you look as though you want to say something, but
yeah,
perhaps you're not.
I did, but I was trying to stop myself. The comment was that the answer just repeated what's in the pleading.
Yes, well, he's going to give you details of it. So there we are. List out all those wasted costs as a result of not having the credit facilities. And then 43.8. Lost opportunity, suitable alternative investments, lost limited potential investments in the sugar refining. Yeah, wow. Well, I think on the face of it, that's all a matter of evidence, isn't it? And what could you usefully provide at this stage, Mr. McGrath?
Well, my lord, without confining our case on this point to it, obviously we've referred to potential investments in the sugar refining joint venture in Liberia and the multi-territory biostimulant manufacturing business. We could provide more particulars in respect of those two, but I'd be loath at this stage, given the way it's pleaded, to confine our case to that. I mean, if we're talking about needing to understand the case that they have to meet, this is something that would come very much towards the latter end of preparation for trial when one's got disclosure and evidence. and one has a better understanding of where the case lies at that point. My friend crosses his head, but of course, you know, they're sitting there with their hands on the chairs, not doing any drafting, and they ought to really just get on with that. This isn't stopping them doing that. They know the case they have to meet. Their case is they deny liability, so they don't need to know any more about 43.8 to get on with taking this case to the next stage.
Yeah, well, I'm with you on that too, but the question of how 43.8 can be advanced is quite tricky, it seems to me. You've come to a figure of not less than 5.4 million, so someone's done something to assess the lost opportunity in alternative suitable investments in Liberia and whatever the multi-territory biostimulants manufacturing business. What are biostimulants?
I have no idea.
Nor do I.
I'm not even going to try and pretend that I do.
It sounds exciting, though.
It must be drugs of some kind.
Well, you could say, my lord, which is not an uncommon answer to particulars or requests for further information, is to say the best particulars that can be given at the moment is, and then you know, some explanation of where that figure of 5.04 has come from, without the guillotine coming down and on it and preventing evidence thereafter.
Yeah,
I mean, we've said what your lordship has said, and your lordship's response to the further and betters, or request for further information, we should say, and so, you know, we're going to be as constructive as we can in the responses, and I think that would be a sensible way of dealing with 43.8.
I'm with you on that, as long as we understand that. Mr. Chairman, are you happy with that?
Yeah, I'm a little unclear what we're getting. There is a pleading specifically referring to alternative suitable investments, plural. Yeah. So someone's decided there is more than one. It includes potential potential investments, plural, in a sugar refining venture, and then you've got your biostimulants. It shouldn't be that hard. So what are the investments, plural, that the pleader had in mind, or that the claimants had in mind when this pleading was signed off with the statement of truth? And what are the potential investments? I mean, it really shouldn't be that difficult. This is clearly this is tail end Charlie stuff. It's but having said that, it's still a $5 million claim. It's not peanuts. We suspect that, you know, it's a classic thing that should be struck out, if not now, in due course. I appreciate we're not on the strikeout territory today, but they should jolly well make an effort to say what the things are, the facts and matters are behind what they've put down.
Yes, well, I think Mr. McGrath accepts that, but there'll be certain limits to what you get, because it'll be the best particulars we can currently give are that the alternative suitable investments are as follows, and it will then tell you about the Liberian joint venture and the multi-territory biostimulants, and it will then tell you how the figure of 5.04 million has been arrived at. And if there then has to be further amendment because they suddenly decide further down the line there are another 10 projects that they could have invested in, then there'll be an amendment and we'll have to grapple with that in due course. I think Mr. McGrath has got the sense of what I'm ordering, and he'll do the best he can. And if there's still room for argument, I guess we'll have to come back, but I'm rather hoping that won't be necessary at this stage. All right, well, the only question that follows from that then is, how long do you need to produce these particulars?
Well,
I'm going to tell you what my inclination is so far as the defence is concerned. I'm thinking the defence ought to be served within a short period of time, that it doesn't depend upon having these particulars, and that you should produce the particulars in what is an appropriate time, and then Mr. Cherryman will have the opportunity to plead to them in a further schedule.
Yes,
if he wants to. Yes. As opposed to simply denying them or whatever.
Well, could I ask for 21 days to produce the answers?
Yes, that seems to be perfectly sensible. And Mr. Cherryman, I was thinking that you'd probably have much the same period for your defence.
Yeah, I think in our application, I think we said 42 days.
Yes.
It is a significant claim. I appreciate Your Honour has made comments already about what our case is, but nonetheless, that is a short period of time. There are individuals who are not under the control of the defendant. It is a heavy matter. People are in different places around the world as well. I mean, giving us a sort of fairly tight timetable to put something in on what is a substantial case, which we say is still a bit of a moving feast, the case we have to meet, it wouldn't be great for us. We did ask for 42. We do think that's sensible. Again, in the great reality and scheme of things, another little bit extra time is not going to make any difference to anybody, especially given that we're going to get more particulars in relation to at least this aspect of the claim. So we are keen on the number that we asked for.
I mean, it's not as if you're starting from square one today. I mean, you've had this pleading since I don't know when, and you originally asked for extension of time to the 21st of November, and we're now 3 or 4 months later.
Yeah.
So I'm inclined to hold your feet to the fire a bit here, Mr. Chairman. I'm hand on heart.
Yeah.
Hand on heart. What can you do?
Well, I think, what did we say? We said 42, but why, if we could compromise at 35? I mean, we are keen that we do need the time. There are commitments we have. We are where we are. I do appreciate you're keen that we get on with it, and we're keen that we get on with it too. There's no question about that. But as part of the justification for not spending money needlessly to date is because we have this application which is proceeded the way that it's proceeded today, and we've got to come to the security of a cost. And what we didn't want to do is to spend a lot of money needlessly in circumstances where we've got very real doubts whether this claim will proceed, either because of the merit or because of the security of cost issue. But that's a separate point.
Looking at the particulars of damage that you're going to receive.
Yes.
The reality is you're not likely to be able to plead anything specific to them other than non-admission of figures and perhaps denial of causation. But you're not going to be able to plead to the specific figures, are you? I suppose you might be able to plead to if the credit facilities don't, whatever it is, there's no basis for the allegation. But the point I'm driving at really is this, Mr. Chairman. How much do you need the particulars of loss in order to plead? And I suspect the answer is not much.
That's fair. That's fair, Your Honour.
We shouldn't forget the manner in which this all came about. Having agreed an extension of time to the 23rd of November, they then waited to the very last day to issue this application, and by default have got themselves an extra 16 weeks. In which, given
during which they've probably done nothing. During which they've probably done nothing.
Well, except they've scoured the particulars of claim to produce a request that went to 97 requests. So they've well considered this. They already know none of these people are available to help them. They've known that for since the 29th of September. They can get on with it. And when they say there's no prejudice to us, there is. We say we're the victim of a fraud. We want to get on with it. We're only reasonable, but we say 21 days is reasonable. We did, my lord, to be fair, in our skeleton suggest 14, alternatively 28. So if we're in a horse trade here, then at the very last, we would offer the 28. But we really don't think that we should go beyond that.
Well, I'm going to say 21 days for the particulars and 28 days for the defence. And I expect the parties to be sensible about that. So if there's either party is asking for extra couple of days, the other side should agree to it and not make a fuss and come back here. I expect parties to behave sensibly over the few days here or there, and given other commitments and all the rest of it. All right.
Understood.
Now, where do we go to? Is it security for costs we go to next?
Yes, my lord.
Yeah, it is.
Right. Again, it may help you if I give some indication on that. It's self-evident that the thresholds are met. It's accepted that they're met. And so the only question is therefore whether it is just and convenient and so on and so forth. My inclination is to think that there should be security for costs, but only up to the date of the case management conference. So, we have a new advocate, do we, on security for costs? Do I understand Mr. McGrath has opted out? You're muted.
I apologise, my lord. Yes, I'll be handling security for costs.
Yes. Are you Mr. Coates or Mr. Stuart Coates? How do I?
Mr. Stewart, yes, my lord.
Very, very good. All right. Well, you may or may not have overheard what I was saying, which is that it's accepted that the threshold is met for security for costs threshold test. And my inclination is to, in the circumstances, to make an order for security for costs up to the date of the case management conference, with liberty to apply at that stage for further stages of costs up to the conclusion of the hearing. So let's start with Mr. Cherryman. Where do you want to take me from those indications?
I'm grateful, Your Honour. I think I was going to jump straight to quantum.
Very good.
If I may, I of course listen carefully to what you've said. On the basis that it's through to the case management conference, as regards quantum, there's a breakdown of anticipated costs that Ms. Fazal, the litigation partner at Head F, has prepared, and that is at 61 of the bundle.
That's the summary in his witness statement, is it?
That's the summary in her witness statement, yes.
Beg your pardon, her witness statement. Yes, got you. And as I totted that up, that's 405,000. Is that right?
Yeah, something in that order.
Yeah.
I was just double checking it myself.
Well, I totted up HADF fees as being 215,000 down to and including the case management conference, and your miserly pittance of 190,000.
I won't comment on that. Other than it's well worth it. We are in a situation. What is relevant in the exercise of the court's discretion, which again I think the parties of course acknowledge that you have, Your Honour, is the fact that the evidence that was put in opposition to the security application is not just interesting, but hopeless as regards the usual grounds on which one might be able to resist what we're seeking in terms of the quantum. If we could look at, please, page 83 of the bundle, which is para 97 of the statement of Mr. Singh. In response to the security for costs application, he very briefly, having conceded, and that's the first time, by the way, we had the concession from the other side, was in the evidence that we got in response to the security application. The concession is at para 96, but there is also an additional concession, which is at para 99. I don't think we need to dwell on that one in relation to the domicile of Singapore for present purposes, or even any further. But if you look at 97, for reasons which will be elaborated in Keshav's written and oral submissions for the hearing of the security for costs application, the court should not exercise its discretion to order the payment of security for costs. And again, I don't know whether my learned friend is going to still take that position or whether he's going to modify his position. But I do understand from the skeleton, any security is opposed. Anyway, Keshav relies inter alia on the following factors. So other factors as well. But principally, it looks like it's a genuine inability on the part of Keshav to pay the Keshav security payment. That's defined as the full amount that we sought, which is 2 million odd for the whole shooting match. Just pausing there, it isn't said what the genuine inability is. That would have been something that one would have expected to be explained. It's not said whether it's because of a legal impediment, a commercial impediment, a management decision, or any financial reasons. It's just a sweeping assertion that it's unable to pay the money. Might just be Mr. Garg says, I'm not going to pay it. He doesn't say, interestingly, that Keshav, and again, he doesn't distinguish between the two companies again, he doesn't say that the companies are impecunious. Doesn't actually say that. So the statement that he makes is completely meaningless regarding the inability to pay what we sought. He doesn't go on to say, in this connection, he doesn't say that the case would not be able to proceed if security in the full amount we sought, or indeed any particular amount, would not be able to proceed. He doesn't say that the claim would be stifled. These are obvious points for any lawyer to have put into a witness statement, if indeed those points had any validity whatsoever. Significantly, he doesn't say that. So just pausing there, we say that given the status of that evidence, there was in fact no reason why they shouldn't pay the full amount. Or if we go alternatively, if it is security through to and including the CMC, there's no reason why they shouldn't pay the amount that we put forward. I should also add in this connection that the claimants haven't put any new financial information before the court to oppose. Well, so I should say they haven't put any financial information before the court to oppose this application, let alone any new financial information. Your Honour will recall that some financial information was extracted from the claimants by HADEF in the autumn of this year. We ended up, I think, with audited financial statements through to the end of 2023. Then we had some very limited management accounts for September, October last year, very, very short form, and then some bank statements for sort of September, October last year. And that's it. Here we are in March. Certainly there was no evidence has been relied upon here as to the financial circumstances. And we made an observation in the skeleton in the light of the fact that the claimants, or one of the claimants at least, was able to pay off the securities or the credit facilities. It says it does in paragraph 38 of the pleading, where that money's come from.
I hesitate to interrupt my learned friend, but it may foreshorten matters if I can indicate that we don't oppose your lordship's indication that an order for security can be made by reference to the staged approach that we suggested in the alternative, i.e. until after the end of the CMC. So that would just leave submissions on the quantum of security.
Very good. That's very helpful. Thank you.
Yeah. And the points I'm making, I'm grateful for that too. I rather hope that was the case, but the points I'm making still go to the question of quantum. So, because what matters here is this a stifling situation? That the claimant's skeleton says this is a stifling situation, but there's no evidence before the court at all to support that assertion, as I was just explaining. I don't know whether we need to look at the deterioration point. There's nothing in that one equally. An examination of the accounts for 2023 for the Singapore, for the Dubai company shows that actually the debts were increasing anyway, and the company was not in a strong state. There's no clear causal link between the alleged fraud and the finances of the company. And indeed, there's no explanation beyond assertion in 97.2. Of the statement of Mr. Singh. Again, it's a pretty obvious point that people take in security for cost applications, and lawyers love writing lots of stuff about that in the light of instructions. But we barely got 3 lines on it. So we submit there's nothing in that, and also there's no evidence. Again, echoing a point I just made in relation to 7.1, there's no evidence how the claimants were able to raise, I think it was $10 million to repay banks' finance in 2024. Where did that come from? And all of this emerges in circumstances when we have no information about the wherewithal of not just the claimant companies, but also Mr. Garg himself. There was a case that one authority, Your Honour, again, you'll just please you'll stop me if I'm going over ground that Your Honour knows well, which I'm probably the case. But there's the case of it's Mucky and Nawan, which we referred to. Forgive me, I've just got to pick up the reference. 1 second, if you would. Yeah, the case begins at 9:10 of the bundle. There are some comments made by the Deputy Chief Justice, which begin at paragraph 12. I say the claimant in this case said that the effect of any order would be to stifle an injunction claim. Para 12. It's the claimant's case that the financial situation and restricted visibility of its financials contributed to the defendant's alleged misconduct. Well, I think the wording's gone slightly wrong there. I suspect it means was contributed to by the defendant's alleged misconduct. So there's that. And then para 13, however, Mr. Muriel, on behalf of the claimant, failed to provide the court or the defendants with a clear insight on how the defendant's alleged breaches did not impact him from obtaining legal advice from his previous lawyers, head F, or from being represented by his current legal advisors. One would assume that the claimant's legal costs have been personally funded by Mr. Muriel, or other sources of funding were sought. And then it's para 14. It's wholly appropriate and reasonable to assume, based on the assessment of the evidence, that the claimant has to some extent taken steps in making enforcement procedures for future adverse cause order difficult. And then para 19. There's comments made about the lack of evidence that was provided by the claimant. It's the last set. In the light of the insufficient and lack of clear evidence, the court could not simply order in favour of the claimant based on the statements of Mr. Muriel. And then para 20, the bottom of the page, it was for the claimant to prove to the court that there was no other way to raise capital from directors to shareholders or other business associates, or whoever has made those funds available for the duration of these proceedings. Its burden of proof that on the balance probabilities is not discharged to simply suggest that the claimant is impecunious, and that impecuniosity is related to the alleged breaches of the defendant. So points which I would respectfully submit are pretty.
You're muted, Mr. Chairman.
I'm sorry. We would say those. So did you hear me speaking? I was reading out various paragraphs from the Maki and Mawani case.
Yes, got that.
Thank you. We say for sure, or equally so in our case, where Mr. Singh has made the assertions he does. He doesn't assert impecuniosity. He doesn't refer to the financial position of the company. He doesn't say. He doesn't even use the word stifle. So going back to quantum, we say it should be in the sum that we've ordered. Head F, a very experienced litigation lawyers, experienced senior partner, has given the assessment that the legal team have arrived at. This is obviously, if this case does carry on through to trial, it's clearly a heavy matter involving serious allegations and a number of individuals. It's going to require a lot of work, and we do submit that the quantum that we put forward is entirely reasonable. In all the circumstances, it's appropriate that the claimants do put that up, and they do so within 21 days of today.
The difficulty I have looking at your figures up to the case management conference is this, that so far as the representations and alliance are concerned, assuming that you can make contact with the people who are said to have made the representations, and assuming they deny, there isn't in fact going to be an awful lot in your pleading. When it comes to the loss and damage aspects, once again, as we've already discussed, it seems to me you're unlikely to be able to plead a huge amount until you've had full disclosure. So it's a bit hard for me to see at present how you could justify the figures that are set out in Miss Fazal's witness statement of paragraph 15. The amount of time that is actually going to be taken in putting together the pleading will be pretty limited, I would have thought.
Well,
I mean, the trouble with this sort of assessment is and I mean, it's always the way on security of cost. There's very little detail at all as to what time and effort is going to be put in. Self-evidently, if we get to disclosure and looking at the details of the losses, there can be quite a lot of work in that. If we have expert evidence at that point, there may be a lot of work in that. But at the stage of pleadings and taking up the case management conference, these figures look to me to be very large indeed. Is there anything you want to say about that?
Well, yeah, Your Honour, yes. I mean, we can't assume that we're not going to get cooperation from everybody.
No.
We can't assume that. We have to assume that we will have cooperation from hopefully everybody. We have to assume that. We have to also look into the question of these alleged forgeries or fraud, whatever you want to call it, in relation to the bills of lading.
Yes.
What's that all about? How did that arise? And all of that is, understandably going to take time. The question of, the authority and what these people are really doing and when and all this kind of the usual stuff. It is possible, of course, as Your Honour observes, that it may be the pleading ends up, at least at this juncture, being a fairly concise document, maybe for the reasons Your Honour identifies. But equally, it may be something more extensive than that. And we're allowing for that. And we submit that in the circumstances, we should be given the benefit of the doubt as to that.
All right. Okay. Mr. Stewart-Coates.
Thank you very much, my lord. Most of my learned friends' submissions went to matters that were almost exclusively for the court's discretion to order security in principle. So I don't propose to trouble your lordship with those points, save to note that we don't accept much of what was said about the evidence in respect of our financial position. We do say there is a lot of evidence before the court, but in any event, nothing now turns on that, we say. Turning then to the amount of security, there doesn't seem to be any real difference between the parties as to the principles governing the determination of the proper amount. It's agreed that it's a relatively broad brush exercise and it's not detailed assessment of costs. That said, the court obviously must have regard to what's reasonable and proportionate, because ultimately it's looking at what costs might be recoverable on detailed or summary assessment. And we do also say, as we noted in our skeleton argument, that it's relevant to note that the DFC court does appear to have taken a slightly more conservative approach, perhaps than has been taken in England, to the amount of security that should be ordered. We've referred there to the Veggie Bar and Vision investment cases. I don't propose to trouble your lordship, with particular paragraph references, but the relevant amounts ordered were 50% and 30% in those cases. My lord, it's obviously
they're all very fact sensitive.
I entirely accept that. I entirely accept that, my lord. We say it's very important for the purposes of determining appropriate amount that the applicant provides sufficient detail of its estimated costs. If I could just trouble your lordship with a single authority, and that's at page 876 of the bundle.
(876).
Yes, at paragraph 54, and this is a judgment, one of the Court of Appeal judgments in the Al-Kharafi case. At paragraph 54, they say there's no sufficient evidence of the costs of the defendant so far incurred or likely to be incurred up to and including the trial. Applicants for security for costs should always provide a detailed schedule showing the breakdown of their total figure for security. Were we otherwise minded to order security for costs, we would be unable to quantify the required amount with any sufficient accuracy. And your lordship, if you could turn up what we have by way of explanation, and that's at paragraph 15 of Ms. Fazal's second statement. That's at page 61.
Yeah.
And we do say it's immediately apparent from that table that it's not the sort of detailed schedule expected by the Court of Appeal in the Kharafi judgment. It's not even a modified version of the ordinary statements of costs in DIFC proceedings, which are expected of an applicant for security by virtue of RDC 25.994 and RDC 38.35. So it's not even at the level of detail that one would get from what's required under the RDC. And for example, there's no breakdown of the number of expected fee earner hours for HADEF or hourly rates. There's simply a single overall figure by reference to a very broad category of the case. So looking at Ms. Fazal's statement at paragraph 15, the costs of the RFI application can now simply be disregarded. Not only was it wasn't brought, but your lordship has obviously exercised the court's case management powers to in effect grant orders for further information. So we can say those can be put to one side. They shouldn't factor within the quantum of security. The second point is that the figures said to represent disposal of the application include figures, obviously, for an application that the court has dismissed today already, or has indicated that it will dismiss, and that's the immediate judgment or strikeout application, and in respect of which we say the defendant shouldn't be entitled to any costs, and that's the extension application. So we say those figures should also fall out with the court's determination of proper quantum for security. So then we're left with the defence and the CMC costs. The defence, my lord, obviously, your lordship has had certain exchanges with my learned friend in relation to the defence already, so I'm not going to repeat points put there. We do say this is an extraordinarily large amount given the circumstances, where ETG has clearly been considering and engaging with the particulars of the claim for 6 months odd, including serving an exceptionally detailed RFI, preparing for this application. It has already been able to determine its position as to liability. We can see that from paragraph 7 of their skeleton argument, and we've had a bit more detail from them during the course of today about particular aspects of their position on liability. And so they've obviously been able to consider with their client, the lawyers acting for the client, what their overall position will be on liability, and also, so it seems from my learned friend's paragraph 7, on most of the relevant aspects of liability. So clearly sufficient work has been done to reach that position. Whether or not it's a lot is obviously a different matter. And thirdly, obviously, it was and seems to remain ETG's position that the alleged weakness of this claim was apparently sufficiently clear to them that they've applied to have it determined on a summary basis. We say none of this is consistent with a pleading that would cost well over $200,000. As to the cost of the CMC, $70,000 is sought. No explanation is given for number of fee earner hours, what sort of matters are expected to be covered at that CMC, noting that an additional $400,000 is sought in respect of disclosure. So one would expect that that 400,000 figure would include the usual interlocutory skirmishes over document production, requests for production, and objections there too. So we say that 70,000 is also very high. There's no proper explanation for it, and that should also be subject to a very stiff discount. My Lord, I'm not sure there's much more I can say on amounts. It's really only the defence and the CMC cost to argue about, and I think your Lordship has our submissions on the amount of both.
Are you putting forward a figure that you say would be appropriate?
My Lord, I think our overall suggested discount was 30%, and I suspect 30% of the amount sought in respect of both the defence and the CMC cost is probably about right. So that would
what does that come to?
So 30% of the 70,000 for the CMC is 21,000, which, given that there's no involvement of counsel, we say is a reasonable amount for what we have to expect will be a relatively plain vanilla CMC, and then the 175,000 sought in respect of counsel costs for the defence times 0.3 is 52,500, and the HADEF costs for the defence, which are 38,306.
13,000 would be it. 13,000 is roughly 30%.
I think that's about right, my Lord.
So that would be a total of 86,000 on your figures. 13
yes,
plus 52 plus 21.
Yes, my Lord.
Yep. Okay. Mr. Cherryman.
Yeah, that's too mean with respect. It doesn't do justice to what's required. We're going to get a request for further information, apart from anything else that's got to be considered. This is a nearly $40 million fraud claim, right? Involving commodities trades. It's not a simple matter. We now got to really get to grips with this and try and get on with this, as we all know, in advance of the case management conference. To come up with a sort of a modest figure like that just doesn't do justice to the nature of this type of litigation. I mean, we all know what this stuff really costs. We all know that cases like this do easily cost $2 million if it goes to trial. We're talking about one of the major steps, and we've asked for 400 in circumstances where the other side have made no effort at all to be forthcoming about what their asset position is. We say it is a realistic number. If one's going to discount that number is discounted by 30%. In other words, if anything, 70% of our 400 would be appropriate.
Right, thank you. I should say that I expect the leading counsel to appear at a case management conference in the ordinary way, because particularly in a case like this, I anticipate that there will be likely to be real issues to be discussed. Only if everything is agreed and it's all perfectly straightforward would I anticipate only having junior counsel or non-advocates present. The advocate who's going to lead out the trial would be the person I would want to see. Leaving that point aside, there's one other element that comes into this equation, which seems to me the question of the costs of today. I'm put very broadly. The position is this, isn't it? And you can each address me, and maybe Mr. McGrath will want to revert to the microphone for this purpose. But the applications for summary judgment and strikeout have failed. There was no application for an order for further information, but because of issues of efficiency, I have dealt with all that in one go, and broadly speaking, met little resistance from Mr. McGrath on the particulars that are to be given. Self-evidently, I'm going to make an award of security for costs, but the question which arises is, what about the costs of today?
So
I don't know who wants to start. It doesn't make much difference who starts. I shall take into account everything everybody says.
yeah, well, these are our applications. We say that we've two things. Firstly, we have substantively succeeded in the sense that we've had to come to court to get progress, whether it had been by way of the Part 19 application, which would have given rise to the order that essentially Your Honour has made today, or whether it's through the mechanism we use today. It is in substance entirely the same materials. So there's really no there shouldn't be any quibble on that. We came to court and got an order against the claimants to do something material to advance this case. As I say, we could have done that by Part 19. It would have cost exactly the same material. So we should have our costs certainly of the Part 24 and strikeout application. One just technical point in relation to that, we would ask the court to consider just adjourning that application to the case management conference without prejudice to any cost issue, because it may be that we will seek to have that restored in the light of the response to the further information, which we're going to get hopefully fairly soon. So we say that also would be an efficient way of proceeding. So to leave that live until at least the case management conference as a separate matter. As regards security, that was opposed. We've succeeded on that as well. And we should obviously have our costs of that. And the matter of I think of the side, I don't know what they say about the cost of extension of time for defence, but that just follows as a result of what's occurred, and there aren't really any material costs. What really matters is the other side have orders against them, which they came to court with no conciliatory approach whatsoever. There was no offer to provide the information at all. There was no evidence containing that information, nothing at all. And as we know, security was opposed in principle as well. So we have very substantially succeeded on this application, and we submit that we should have our costs of our application and including the cost of today.
Stuart Coates or Mr. McGrath, I don't know which one of you is going to address the whole question of costs in the round.
I'm afraid, my lord, it's me on the question of costs. We say it's obviously wrong to suggest that the other side succeeded on their immediate judgment / strikeout application. They got, or the court ordered something entirely different to the application that was actually brought under a completely different procedural route. We do say it was highly unreasonable to go for the nuclear option of a strikeout in circumstances where the obvious route to meet their complaints was RDC Part 19, as we pointed out in our skeleton argument. My lord, your lordship didn't even ask to hear from Mr. McGrath on that application. There was quite clearly a completely constituted claim in respect of even those causes of action require loss, still more so if the claim is in contract. We say that essentially everything that was done in response to the immediate judgment / strikeout application was a complete waste of the party's time. The only reason something productive came of that application was because the court exercised its case management powers of its own initiative. And so we say we're plainly and obviously the successful party on that application, and we should have our costs on that basis.
All right.
And as to security for costs, we say essentially, my lord, it was whilst we accept that the court exercised its discretion to order security, it was something closer to a score draw, in that our obvious alternative case was that security should be ordered by reference to a staged approach, which is the approach that the court ultimately adopted. So we'd say no order as to costs on the security for costs application.
Now I've got, haven't I, schedules of costs from both of you. Let me just make sure I can find those. Here we are.
Our schedule is at 1330.
Oh, thank you. Right. I think they've been sent to me separately as well. So
I should say that we haven't sought to distinguish between the applications because there's obviously a cross-fertilization. There's a cross-fertilization of the material.
Okay. Right. Well, I'll tell you what I'm going to do. I'm obviously going to make an order for security for costs. 21 days, is that
yes, my lord,
appropriate? And by way of first-class bank guarantee or other form reasonably satisfactory to the defendant?
Yes, my lord, although as far as I understand it, it's more likely to be a payment into court, but presumably that's
okay. Well, all right, I'll say payment into court or bank guarantee or other form reasonably satisfactory to the defendant. 21 days. What I will do, though, is to reflect upon the figures and on the costs of today and come up then with an appropriate order. I will give you a reasoned judgment for my decisions today, which I'll draft immediately following this hearing. So you'll get that and the figures sometime over the course of the next couple of days once it's been processed by the registry in the DIFC. But you all know where I'm going, you know what the results are, and as I say, you'll get a formal order in due course. Anything else I can deal with today?
I'm just looking at instructions, if there are any from my instructing solicitors. If you might give me 60 seconds,
yes,
I would appreciate
sure.
it.
Nothing from us, my lord, save to I've been asked to ask your lordship if your lordship's received the split statements of costs that we've provided to the court by reference to the applications, but I suspect that's a matter that can be addressed in due course.
Well, is this just looking? Chances of hearing worked on document. Oh, I see. Yes, there's one for application for security for costs, is there? And there's another one for summary judgment. Yes, I've got you. Yeah.
Thank you,
yeah, I've got all that. I'll look at all that.
Yeah, as loath as I am to mention this, the other side only sent these split schedules, so to speak, a few hours ago, so we haven't had a proper chance to consider them. But anyway, as I said, our schedule of costs is on the basis or covers everything. As I commented earlier, because there's such an interrelation between the two applications because of the underlying financials. It's really at the heart of this. If it's desirable, Your Honour, we would ask for the opportunity to put in, if it's necessary, I should say, and helpful, we would ask for the opportunity to put in separate cost schedules, splitting the applications. But our primary position is that it shouldn't be necessary, certainly on our position.
The short answer is that whenever the court makes an assessment of costs, it takes a fairly broad brush approach. And to be frank, I doubt if any further submissions are going to help me. I can see what's being said in both sides' statements of costs, and I shall make a decision accordingly.
Okay. One further point that occurs to me, given, Your Honour, you're now making the order for security, we consider the question of the timing of the defence. The order for security is 21 days, I think, and the defence was, is it 28 days? I've got it. We do submit that it would be appropriate for the defence to be properly keyed off the payment of any security, because this is the whole point, we don't want to run up costs needlessly. On the face of it, these are companies that may well be insolvent. We don't know what they're up to. We could end up spending a lot of money on a defence and they don't make the payment in. And that's the whole point about the principle of security, is to ensure that we have protection for costs that we're going to incur. We're not going to have that protection until we know where we are with the security payment. So we would say that that's actually a reason why the defence should be pushed out a little more, to ensure that we've actually got security. Otherwise, it defeats one of the main purpose, or the main purpose of a claimant providing security. So I think at the moment we would be 7 days after the payment of security. So we could ask for an additional 14 days after the payment of security. So additional 21 days after the payment of security. We're not going to just sit on our hands and do absolutely nothing after today.
No, but I'm afraid you must get on with it, and it will take the risk. It's going to be 21 days for the payment in, and it's going to be 21 days for the furnishing of the further information, and you've got 28 days for your defence. And if there's a failure to obey the order for security costs, well, we'll cross that bridge when we come to it.
Understood.
All right. Thank you very much. If you would all like to sign out, except for Lena, the associate, that would be very helpful. And I can then have a word with the registry. Thank you very much for all your submissions, and a pleasant morning.
Thank you.